Good afternoon. My name is Ryan Foltz. I'm an attorney at Beresford Booth. I've been practicing for 25 years, and my practice focuses on construction litigation. Today, we're going to examine some pathways to recover attorney's fees in a construction dispute in Washington. Fee recovery can dramatically alter and affect case strategy and also settlement leverage and negotiation. These aren't the only way to recover fees in Washington, but are the most common routes to recover fees in a residential construction dispute. Recovery of attorney's fees is limited in Washington, so you typically need one of three routes to recover: under a contract, by statute, or some recognized ground in equity to allow the recovery of attorney's fees. Obviously, the most direct route and the best path is to recover fees under a well-drafted contract. A typical prevailing party attorney's fee provision can be very profound in litigation, when the cost of litigation many times can be half or more than the actual amount in dispute between the parties. Even one-sided attorney fee provisions can be deemed mutual under Washington's reciprocity statute. So even if there is a poorly drafted contract that isn't in your favor, you can use that attorney fee provision to your advantage once litigation is underway. There are a number of statutes that allow for the recovery of fees. In residential construction, one of the most specifically drafted statutes to protect owners is the Contractor Registration Act. Under that act, the contractor is required to provide a disclosure statement prior to commencing work on a project. Frankly, this is a commonly missed procedure by contractors, and when they fail to do this, it exposes them to attorney's fees under the Consumer Protection Act. Failing to provide this disclosure statement is deemed to be an infraction under the Contractor Registration Act, and that infraction is also a per se violation of the Consumer Protection Act. Under the CPA, you can recover your attorney's fees, actual damages, and treble damages up to $25,000. Also, for the contractor's noncompliance with this statute, the contractor is unable to bring a lien claim, which is a very, very significant defense, being as liens are common in residential construction. Under the lien statute, there are a number of ways to recover your costs and fees. Importantly, if a lien is filed, the prevailing party, either the plaintiff or the defendant, can recover their fees. So this applies whether you're prosecuting the lien claim, whether you're defending against the lien claim, or whether you're simply trying to bring an action to remove a wrongfully recorded lien against the property. The costs are fairly robust. You can get your costs for title reports. You can get the cost for the claim of lien and any necessary litigation expenses related to the litigation as to the lien. In Washington, you're not typically allowed to recover your attorney's fees in a tort claim. There is an exception for omissions or defects in a Form 17 disclosure, and this is a seller disclosure statement that's required during the course of sale. If, for example, a seller omits a defect in the property, or if a seller fails to disclose that there was renovations or remodels, and let's say that inspections or permits weren't pulled, that claim is deemed to be a misrepresentation. And under Washington law, the way that the courts have interpreted that cause of action, the claim is deemed to be on a contract. And so in the purchase and sale documents, you'll typically find an attorney fee provision, and the courts will allow you, even though it's a tort claim, the court will allow a prevailing party in a Form 17 negligent misrepresentation claim to recover their attorney's fees. Equity is another route to recover fees in Washington. This is commonly referred to as the ABC rule. And essentially, it's when an owner is exposed to litigation due to the wrongdoing of the contractor. The way that the rule works is fairly straightforward. When the owner is compelled to defend against the wrongdoing of the contractor, they're exposed to litigation with a third party, and the ultimate responsible party, the contractor, assuming the facts are proven in the favor of the owner, the owner can recoup their attorney's fees and costs for the litigation resulting from any wrongful acts from the contractor. So in the construction context, primarily you'll see this if an owner is forced to defend a third-party claim caused by a contractor or the contractor's subcontractor's negligent work. If you have any questions, feel free to contact me. Like I said, my practice primarily focuses on construction litigation and construction-related disputes. Beresford Booth is also a full-service law firm that provides legal services and counseling for all sorts of disputes, estate planning, family law, and business law. Thank you.